do another live. Today we're going to talk about the proposed rulemaking and the notice for comment that was released on July 1st by USCIS, and we're getting a lot of questions about it and some nervous investors. So let me explain and walk you through it, some of the proposed changes, but also what does this rulemaking mean? So I always start out with a disclaimer that anything I'm telling you today is not legal advice or financial advice. Your situation is unique. So when you do decide to pursue the EB-5 program, you should get a consultation with an immigration attorney about your specific set of facts. You can advise also with a licensed FINRA broker regarding projects and specific risks. These sessions is only, but it may help you to know which questions to ask the professionals you're working with. So on July 1st, 2026, USCIS, I apologize, I also have calls. As we're doing this live, I have calls coming in, so occasionally I will have to turn them off. Hopefully it doesn't interrupt our recording very much. So proposed rulemaking came out, and I hear a lot of investors, a lot of individuals, prospective investors who are researching this program worry or ask about changes that happened on July 1st. So let me be clear, there have been no changes made on July 1st, 2026, right? The document that came out is a proposal for future changes. And they're not even necessarily changes, but most of it is more, the types of regulations that will come out, and it's more clarity on the law that was passed in 22. So let's back up and understand how our legal system works a little bit. Congress passes law, and then depending on which program the law reflects, so if it's an immigration program or if it's a tax program, then you have the government agency that is actually in charge of enforcing and implementing this law or program. So in case of EB-5, it's an immigration program. So it is USCIS, U.S. Citizenship and Immigration, that manages that program. And so once the law is passed, the agency that is implementing this program is supposed to make rules via regulations within the spectrum of that law. So how to practically apply it, which forms are going to be filed, which evidence is going to be submitted, and so on. Because Congress just gives us an overview, big picture of what needs to happen. And then the agency actually, creates specific rules through regulations on how certain sections of the law are going to be interpreted and how they're going to be utilized. Like, for example, Congress can say, the investor has to show that they have obtained funds in a lawful way. And USCIS is going to say, okay, to show lawful funds, we're going to be accepting 7 years of tax returns. We're going to be accepting pay stubs. We're going to be accepting these additional documents. And these are kind of the outlines. So what happens is, obviously, it takes some time for USCIS to come out with these regulations. Let me fix this just because we're, apologies. We have a little bit of a strange lighting situation. For some reason, my phone wants to keep dropping. But so the point is, it takes USCIS sometimes to create these regulations, right? And the rules are they cannot just publish regulations without giving the public first a notice and a period to comment on what they plan to do, which is what they're doing now. So the notice and comment period is 60 days. So they published on July 1st, they simply published their proposed rules. Now for the next 60 days from July 1st until end of August, they're going to be receiving public comment that will get submitted to them. Then they have to read and process all these public comments, take them into consideration, ask questions back to the public, and based on the information they receive, they are supposed to make the final regulations, right? So practically speaking, in most cases, this takes months. So once the notice and comment period is over, it actually takes weeks and weeks and usually months for the agency to review all the comments, internally discuss them, implement them, see how it's going to change each section, and then eventually publish the regulation. So I obviously cannot speak to any agency, but my guess is we're not actually going to see the new regulations until sometime in the summer of next year. At the very earliest, it would be like around November or December of 2026. And that would be like lightning speed. I don't think it's actually doable, but the earliest we're going to see the actual regs published is going to be a few months from today, which today is July 14th. So that's first. These regulations have not come out yet. And the most important thing is things can substantially change. That's the whole point of public comment, is we get to comment, we get to use examples, we get to use statistics and data to show how these proposed rules can possibly affect the investors in the process. So we are taking this very seriously. I'm actually in the American Immigration Lawyers National Committee. Every single committee member is working really diligent right now to provide comments on different sections of this proposal, as are plenty of other organizations involved in EB-5, such as USA and so on. So we are going to be providing these comments, to continue to advocate for a stronger, better, well-regulated program, but also workable one that investors from different countries can work with, and one that requires reasonable documentation. So I will address one of the biggest concerns. So kind of two big concerns that people have expressed since this notice has come out. Number one, can this be applied retroactively? Specifically, a lot of people are freaking out because one of the proposed changes is for the projects not to be able to use what's called bridge financing. So right now, bridge financing is present in almost every EB-5 project and has historically been allowed. What is bridge financing? That's when a developer temporarily borrows money from the bank or a lending institution, starts building with that money. And as they are collecting EB-5 investors, and as EB-5 investors are contributing their investment to the project, they use the EB-5 money to replace the bridge financing, right? So that's called a bridge loan. It's present in almost every other project. So one of the concerns for the general public is, if bridge financing is no longer going to be allowed, then potentially almost every single project that right now is in the market that investors have already invested in and filed their petitions could be denied, right? So I'll address two things. On number one, I would like to think, and I have very strong hopes, that this is not going to make it into the final regulations. There's going to be so much public comment and so many examples from regional centers and prospective investors about the fact that if you remove a bridge financing as a tool, EB-5 program is going to be virtually unusable, because a developer cannot sit and wait to start the project. It takes sometimes a year or two to gather multiple individual investors to provide the money to a project. And a developer simply cannot sit on a project that is already approved, permitted, and is ready to go for 2 years while they're waiting for this group of investors to come in. At the same time, it would also negatively impact the investors, because the first investor who would put in their funds would potentially have to wait until the last investor is in the project before this project moves forward. So then that would affect their timeline on the job creation. So it is just kind of a terrible idea, plus all the additional risks for the project, right? What if they need 100 EB-5 investors, they only find 50? If a project doesn't have access to bridge financing, they're going to fail. So bridge financing helps to make sure the projects don't stall. It makes sure that we're not losing the jobs that we're creating. it's a really good and a very practical tool. Now, there are other things that we can do to affect USCIS's concerns. I think USCIS just doesn't want to see projects that don't really need EB-5 money. Like, they've already financed the entire deal with bridge financing and developer capital, and now they're coming in and trying to take in investors once the project is fully finished. So I think that's more of a problem for USCIS, and there are other ways to address it. Like, for example, that investors still have to be, their investors' funds have to go directly into construction operation, or they shouldn't, you cannot attract EB-5 investors if your construction process is finished, right? So I think that there are, other ways to address it. So number one, I hope, and it's certainly very likely, that this proposed rule is not going to make it into the final regulations. So no reason to panic yet. A reason to submit a lot of very well argumented and supported comments, but no reason to panic yet. Number two, the biggest question is, can this regulation be applied retroactively? And in theory, USCIS can say, this isn't new rulemaking, this is a change or an amendment where it's an interpretation of the 2022 law. Honestly, in my personal opinion as an attorney, I think there's almost zero chance any court is going to uphold that. Instantly, they're going to get sued by every single project that is currently taking in EB-5 investors and either had its 956F approved or already filed it, because bridge financing was always allowed. So the interpretation of the law for the last 20 plus years of the program allowed bridge financing. If you're going to take such a major departure of that interpretation, that's an equivalent essentially of new law, and that's why you need period of notice of commencement, new regulations. So applying that new regulation retroactively would violate a lot of other kind of provisions that we operate under, constitutional provisions. And so I think USCIS, they're not dumb. They don't like to get sued. And they understand that if they try to apply this proposed rule, if it even passes, but even if they pass this rule in the future, if they try to apply it retroactively, they would put themselves in the position where literally hundreds of projects, and we're talking about thousands of and tens of thousands of investors, would have no choice but to sue them, right? And that's just so much litigation. Plus, in my opinion, as an attorney, I think litigation that would most likely prevail. But just the legal burden that USCIS would put themselves under if they try to apply this retroactively, I think is so enormous that I don't think practically they're going to try to do that, right? USCIS, unfortunately, is known to change their mind on provisions, change their mind on how they interpret the law. And sometimes they approve a certain model and then they stop approving it and issue denials. But that tends to be forward-looking, right? They will approve a certain model, stop approving it, and start issuing denials. So they don't go back usually and reverse all these hundreds of prior approvals, right? Because they would, again, get sued. So I think for practical reasons, USCIS, even if they pass this new proposed rule, it departs so much from every prior interpretation that they have approved, that for practical reasons, I don't think they're going to try to apply it retroactively. If they do, there's going to be litigation, and I think there's an extremely high probability that we will prevail on that litigation. So that's first. Second, I actually, so the retroactive, I guess, application is more of a second argument. First argument is that we don't even know if this proposed rule is going to take effect. Everything else, I won't dive too deep into some of the other proposals or changes, but it seems like that was one of the main ones that is going to be a potentially big departure. and we're still kind of combing through all the other proposed changes and analyzing them. But I do encourage professionals in this industry, if you really are interested in this topic, you should analyze the proposed rules and submit your comments. And you can work with other organizations such as AILA, American Immigration Lawyers Association, or IUUSA, or EB-5 Alliance Network, to, again, make comments. And what do I recommend for investors now? Or what would I say to consider and discuss with your attorneys? The word recommend is not, I guess, I don't want it to be misapplied. September 30th this year, petitioners who file their petitions by September 30th this year, 2026, are grandfathered in. So they're grandfathered in under the current law, and there are arguments to be made that they're grandfathered in under the current law and the current regulations, right? So those who are filing their petitions by September 30th have a stronger chance of not having future regulations applied to them, because that's part of the legal provision that they're being protected by. They're protected from future, technically legislative changes, but one could argue that they're filing under the current interpretation of the law, and their petitions should be reviewed under the current interpretation of the law. So more reasons to consider and get your application in before September 30th and before these proposed changes. Also, I actually think the fact that these proposed rulemaking changes are even coming out a year before the program is sunsetting is a really, really positive sign, because if USCIS for a second believed that the EB-5 program was not going to likely be renewed in September of 2027, they would not be spending their massive resources right now issuing these proposed changes, collecting the comments, and working towards regulation, right? Why? Because what's the point of publishing new regulation next spring when you know that Congress is going to extend or pass the new program? Or if they thought the program was gonna expire, then they would not be making these proposed rules, right? Because it's just a lot of effort to do something that's going to expire less than a year later. So I think it's a great sign that they also have very strong faith, and based on what they know, that this program is very, very likely going to get extended in September of 2027, and they seem like they want to be prepared. They want to offer their interpretation of the current law, so that when Congress is potentially making some changes next year, they can consider those in. And because they also, I don't think, expect that Congress is going to change much. That's why they're already kind of writing the interpretation based on this law. If Congress doesn't change the program very much, they can just take these regulations and kind of amend them a little bit, and publish new ones or upcoming ones when the new law comes out. So, long story short, I think that we are looking overall, it is a good sign. It's a sign that USCIS believe this program is going to continue, is going to be extended. That's why they're putting in so much effort in getting updated regulations. No, I don't like the fact that they're suggesting to remove bridge loans. I think it's super impractical and it's going to have a very negative impact on the EB-5 industry, like just the quality of projects, right? And the quality of safety for investors' principal if they make that change. But I have strong faith that they will not actually go through with it. And if they do, it's going to be forward-looking, so we'll have to look for some solutions there. But stay tuned. In the meantime, the message I wanted to leave you guys with is these are just proposed changes. They have not yet happened. Likely and practically, they're going to take months to be implemented. So if you are planning to utilize this program, the September 30th, 2026 marker is still a very good one. to try to get your application in to be protected by the current grandfathering protection. And as I've already said, I believe that substantive changes such as use of bridge loans should not be applied retroactively. All right. Thank you guys so much. I hope this session was helpful. If you need any advice or help, please reach out. And of course, if you're looking for help with project selection, I, as a licensed vendor broker and a former immigration attorney, would be pleased to review a case and see if there's something we can do for you to help you analyze projects. Thank you.